guaranteed to corporations the right to do that. If that's so, it's not entirely illogical to take the next step and find that a corporation has the right to similarly express itself on whether a candidate should be elected or not. Will the impact of this decision be as great as the dissenters believe and as some have written in the press? I tend to doubt it. For some of the reasons I've already mentioned. In addition, the majority opinion notes that in 26 states, there are no limits on independent corporate spending for or against candidates. And I don't think there's any evidence that in those states that has resulted in corporations disproportionately affecting elections. Perhaps that is because the dangers inherent in openly taking sides in an election are too much. In other words, think of yourself as somebody who's selling, whether it's cars or widgets or whatever. You have an important corporate name. Do you really want to put it on the side of a liberal candidate or a conservative candidate and thereby offend maybe 40 or 50% of your potential purchasers? I tend to doubt it. And I think that that's why in those 26 states, corporations have not been disproportionately spending their own money. And my guess is that it's probably unlikely that they will do so, particularly because if it matters so much to them, they still have their PACs, their political action committees, as do, of course, blocs on what may be the other side, the liberal side, unions, and so on.
Don.
And that's it.
Okay.
Okay. Did I went to 10 minutes too long? My apologies.
Not a problem. So we'll open things up now to Q&A. Please ask questions of Judge Coburn.
Oh, thank you. Hi, thanks. What's to prevent a corporation from funneling money under Citizens United to a nonprofit and thereby hiding their identity and escaping the public relations aspect of supporting a candidate?
Nonprofit corporations are under the same limit as profit corporations. They, too, cannot give money directly to a candidate. So there would be nothing to be gained by doing that. Yes. Oh,
Another question over here.
Do you really think anything needs to be done about judicial activism, or do you think it's kind of just the dirty truth of the judicial system that generally will result in something that maybe not the general public agrees with, but upholds the rule of law in the long term?
It's in essence is the question of what is judicial activism a danger? Does it endanger our democracy, I think, and result in unelected officials deciding issues that we think should be decided by the majority? It's an enormously complex problem. We're dedicated to two things in this country. We're dedicated to majority rule, but we're also dedicated to minority rights. Minority rights, individual rights, I mean, not minority rights, individual rights. And individual rights are, in fact, not clearly defined in the Constitution itself, and they never have been. So that activism in the of the proper sort, not just giving an opinion because that's what you want the law to be, is something that is intrinsic. It's unavoidable. Frankly, I'm among those who look at the courts and feel that although a lot of good has resulted from activism, that harm has resulted from it as well, both at the state levels and the federal levels. But it's not a left-right political thing. Depending on the time that you look at, there have been times when the court has been more conservative than the general majority, when it's been more liberal than the general majority. And whether the decisions are good or bad, you know, depends on your view. I think judges need to think hard about judicial restraint. And Citizens United is probably a good example of that, where, you know, in my view, I think Stevens in dissent probably gets the better of the argument, and we'd probably be better off and truer to the Constitution if we recognize that. But it's, you know, you create a monster and you're stuck with it. One of the things I thought about when I was getting ready for this is Frankenstein, Dr. Frankenstein, and his monster. Did his monster have a right to due process? I mean, the Declaration of Rights, the Declaration of Independence talks about we the people to secure our liberties. It doesn't talk about corporations. So I suppose the citizens had a right to kill the monster that was created not by God, but by man. Well, we created corporations. I mean, corporations are total fiction, something that a concept that people developed. Why can't we limit what they do? Or why can't we leave the limiting to the majority? Why isn't that not a majority decision? And yet you look at an issue like the referenda case and say, my God, shouldn't a corporation be able to fight against a referendum that maybe is going to put it out of business or harm its business in some way? I think the answer is to keep pressing judges to exercise restraint, but recognizing that that's not simple. It's not just liberal versus conservative, and understanding that for the most part, though it may not look that way from outside the court. From outside the court, it's much easier to say that's the left wing, that's the right wing, and things like that. If you actually talk to the justices, most of the time, 99 out of 100 times, probably even in Bush v. Gore, you would find that people were going about their job analytically, analyzing legal principles, and not consciously indulging themselves in putting their own view in place. But I'm not sure about that. I know of one case in New Jersey, one famous case in New Jersey, where the Chief Justice and the Supreme Court consciously did an interpretation that was clearly wrong, and they knew it. It was a good decision, actually.
You can look for Judge Coburn's movie Frankenstein's Monster and Civil Liberties this summer. It will be a 3D movie. In the meantime, we have a question in the second row here.
Why do you think, say for the Supreme Court, for example, would take a case with such a narrow scope and broaden it like they did in Citizens v. FEC, or say Griswold v. Connecticut, which established basically the right to privacy? Why do you think courts would take such a case with such a narrow scope and then broaden it the way they do?
I think if you talk about Citizens Union, I think Justice Kennedy honestly believed that the case, Austin, that was decided before was terribly, horribly wrong. And that it was important to vindicate the First Amendment, that the court reached the issue and decided as he did. I think he really believed that.
If the Congress did pass